Good evening and welcome to the Scio Local Road Advisory Committee meeting, September 7, 2022. I'd like to call the meeting to order at 6:32 p.m. Roll call. Linda Smith, present. Roy Townsend is absent, sent us a note. Jillian Kerry. Here. Groden.
Present.
Ian Hubert.
Present.
Kathy Knol. Present. Rakesh Sharma, absent. Patrick Shields.
Present.
Bob Walsh.
Present.
Thank you. I hope you've all had a chance to take a look at the agenda for this evening. I'd like to ask if anyone has any additions, amendments that need to be made. Hearing none, would someone be willing to make a motion to adopt this evening's agenda? Ian? Second by Walsh. Thank you. Just by a vote of yay or nay, all in favor of adopting the agenda, say aye. Aye. Thank you. We actually ended up with two sets of minutes for this evening. I have the June 2022 minutes, which were discussed at our last meeting, but had a couple minor amendments. And then I do have the July 2022 minutes that came in as a late add. I'm sorry. The August 2022 minutes, which came in as a late add. Are we willing to accept the June minutes as presented? Yes, Jillian.
I don't see the correction, well, the one correction. And it says, or two, because Bob Walsh, Bob, you were here.
Yep.
And it says that you had attended by Zoom, and then Sandy Ryder was not the person that commented, it was the Zoom account that the Bogans had used.
Right. And this was sent to me in a PDF format. So I did not retype the whole thing. How do we want to handle that? I believe that this set was made by Rakesh for me, and I was not able to get a hold of him to make the amendments.
Okay. And should the person that takes the minutes for that specific meeting, they should be listed?
That would be helpful.
Okay, so we'll add Rakesh.
All right, I guess my request would be if you're doing the minutes for the meeting, could you please forward them to me in Word so that if I have corrections, I can do so. I can retype these and make the correction that the date is incorrect on the top. I'll just have an extra zero. The Bogans came in through public comment under Sandy Ryder, and Bob Walsh was present. All right, that being the case, the minutes that Roy Townsend forwarded to us, did anyone have any questions or concerns about those?
The one thing that if we agreed to include the video link in the minutes, so that the public can go to that and, you know, for more detail.
Quite frankly, I don't know how to get to that video link to find it, to insert it. Kathy, do you know so that you can add it to this evening's minutes?
No, I don't know. I can find out though.
So, yes, we can begin doing that. I guess I'll have to ask as well. I could put it into Roy's minutes, and then we can revisit those in October. All right, so we will table both sets of minutes as we have not quite got complete yet, and move on to communications and correspondence. We did not get any new letters or direct requests to the RAC other than the Park Ridge correspondence back and forth. Bob, do you want to speak on that?
At this point, we're waiting for the estimate from WCRC. It's now overdue, as I mentioned to you, about a week or so. And, Amy is waiting. We're all waiting. I was going to ask Roy if she has the contact. I'll send Roy a note, email, see what's going on.
Had anyone else had any contact from the public that they wanted to share with the committee this evening? All right, seeing none, we can move on to public comment. If there's anyone that would like to speak to the advisory committee this evening, 5 minutes or less per person, please. Is there anyone in the audience that would like to speak?
Hi, Kathleen Brand. I would like to personally thank Jillian, Kerry for putting this meeting together. This kind of information for residents is crucial. I can think of folks on Bandera Drive that have struggled with this process. We're wondering if they really actually overpaid in doing some of this. I have a question. It says there's quite Q&A at the end. Is that for the public?
Yes, for anybody that has questions regarding the presentation.
So it's not just for the committee?
Right.
Okay, thank you. Appreciate it.
Is there anyone online that would like to speak?
Ian, could you raise your hand just to test this, to make sure I'm doing this properly? Please.
Raise your Zoom hand so she can say she has no Zoom hand. She just wants to make sure she's.
Yes. Find it. We're gonna clap. Did you see that?
Oh, okay, I do see it. So it looks like there are no public comments for anybody wanting to speak at this time.
All right, so we'll close this portion of the public comment for this evening. Under new business this evening, we have a presentation by Mr. Joe Turner, who is an assessor, level 3 assessor and a special assessment district expert. Mr. Turner, are you ready to begin?
Yes, how is my audio?
Perfect.
Okay, well, first let me congratulate the committee members and those who are active in this. I've presented to several townships, and I think that the end result has always been a good sharing of information. So I hope and expect that'll be the end result for today. A meeting of this nature can be important. It avoids litigation and costly mistakes. I think it's a really wise thing to do. I'm aware of at least one township that I dealt with that just plugged ahead on a special assessment under PA 188. And after spending more than $250,000, they had to cease the project. And so hopefully this will work out for you. We're going to be discussing only the basics of the special assessment process. This is an obscure and a complicated portion of the law. And there's only a very few attorneys across the state that actually deal with specials frequently. So I'll be speaking as an assessor. I'm not competent to speak as an attorney, and it's not my intent to indicate any kind of legal knowledge. As an assessor, we're sort of like law enforcement officers in the finance area. We don't make the laws. We're required to enforce the laws by providing assessments. And if the law is incorrect, it goes to a judicial body. So that's the role that I'll be focusing on today. It's called a ministerial process. But in that conversation, I will provide some references for each of you. And I understand this is recorded, so you'll be able to go back at your leisure and take a look at some of the court cases that are cited and things of that nature, the statutes. I want to make sure that everybody feels comfortable. And so I've provided some background. Let's see here, forgive me. So I'm going to provide a background information before we get into the specific act that you're working with. So first, I'm going to explain what a special assessment is, as I understand it, and the process that's involved. We'll touch on that. We're going to articulate or talk about some of the guidelines, obligations, and protections. I don't think many taxpayers actually understand how many portions of the law are there to protect them, to protect their constitutional rights. So I'm going to show you several of those things. And the jurisdiction that uses a special assessment is also under obligation to do certain things. In ad valorem property taxation, or the taxation that you'll encounter when somebody assesses your home for the ordinary property taxes, the concepts are equity and uniformity. So basically, an assessor starts out with a particular cost figure and then values similar houses, they use the same numbers for all the houses, and then they make adjustments, and that's where the equity comes in for the neighborhood, for the quality of the home, for the way that it's been maintained, et cetera. In special assessments, it's very different. There are only two major concerns that are important in the special assessment process, and we're going to touch on both of those. One is called necessity, and a special assessment is basically a charge for some form of public improvement that made an individual taxpayer's property more valuable. And that more valuable thing is called benefit in the legislation and in the court decisions. So the two words that we really want to know about today are necessity and benefit. Then we also need to know about a thing called at-large and a special assessment. So almost everyone is familiar with the special assessment concept, that a public improvement goes in and they have to pay money. The at-large component is the component that has to be assessed to a public body, and that public body can pay it out of their general fund or through a bond issue or some other way. But those monies, those charges can't be levied against the citizen. There's a very unique valuation problem or challenge with special assessments because it's called an externality. So think about Three Mile Island, where we had a nuclear disaster, and people that were downstream or downwind from that nuclear disaster probably saw their values go down. In mid Michigan, we had some dams that broke, lakes disappeared, and so probably values dropped. To determine how much value was lost or gained is more difficult than just to appraise a single family home. And so we'll talk a little bit about that, but it's known in the trade as an externality. Then I'm going to provide various judicial decisions. They're only there to emphasize a particular point or let you hear the actual language of the court so you can look for yourself. I think it's important for us to remember that laws are written for you and I. They're not written for only attorneys and only judges. For us to follow a law, we have to understand it. And so generally my understanding is that the interpretation of a statute is its clear meaning. And so that's why I'm giving you some of this language so you can look at it for yourself. Then there are two road legislations that are commonly used, and one will be Public Act 188, which I believe the special assessment being contemplated will proceed under. And then there's Public Act 246. Both permit the paving of roads, but both of those laws, they vary in terms of the things that they can be done under the law and in the way they approach the understanding of the law. And the last item, which will be relatively short, but it's an introduction to how to appeal your assessment if you feel that you were improperly assessed. So here's an actual definition provided from a court decision, and it was a Michigan Court of Appeals decision. And there are two kinds of decisions that you might review. One is called published and one is not published. So any decision that's published is there to refer to as a precedent. And so there was some sort of question that was answered that would be useful to other decision makers. Sometimes there's more routine decisions. And again, I'm not an attorney, so I'm not, I can't tell you exactly how the justices do what they do, but where it's more of a routine decision and they've heard the same kind of case over and over again, they don't publish it. But in this particular case, the definition of the special assessment that was a part of the analysis of the case was really well written. And so in the classes that I teach, and by the way, I've been licensed in the assessing field for a half a century now. I worked for a municipality for 30 years, and I've had my own private firm for about 20. My goal was to help bring people together to work with townships and private entities, and if there was a dispute, to try to resolve it so they didn't have to go someplace else. But I found this to be a very useful application in some of the discussions. So the first thing you should know is that a special assessment is not a tax, and that's a tax in the normal way that you think of property taxes. A special assessment is a specific levy designed to recover the cost of improvements that confer local and peculiar benefits upon property within a defined area. What that really means is that government put in something or made a public improvement used by everybody that somehow benefited a particular piece of property more than the public at large. And where government makes the property owner richer, they have a right to recover some of the money that was expended on that project. So if they put a sewer line through and they make a tap that goes to a house, and so now the builder can build on that lot, then the government unit has a right to secure money from the property owner that's reasonably related to the cost of creating that sewer line. So then special assessments are sustained upon the theory that the value of the property in the special assessment district is enhanced by the improvement for which the assessment is made. And basically, there's a geographic distribution of value. So again, if we refer to, say, a school district, it's very clear to most people that some school districts are more attractive than other school districts. And when that happens, you're going to see property values change, and you might see the demographics change because people who are trying to get their children into a particular school district may very well move there. If the demand is higher, then the prices rise. By the same token, if there's a school district that's not as attractive as a nearby one, you may find that those property values are a little bit lower. So there's this geographic component that has to be analyzed. And today we're going to talk very briefly about two districts, a service district and a special assessment district. And I'll explain more about that later. A special assessment will be declared invalid only when a party challenging the assessment demonstrates that there is a substantial or unreasonable disproportionality between the amount assessed and the value which accrues to the land as a result of the improvements. What that means is that government can't dig into your pockets and tell you they need $10,000 when the value of your property only went up $2,000. There has to be a reasonable relationship between the financial burden that's placed on the taxpayer and the amount of money that the jurisdiction asks for. And there are court decisions which have limited or put caps on that amount of money. At the same time, they recognize that appraising property is kind of an art, it's not a science. And it's very complicated. Some buyers are really good negotiators and get a top price. Some sellers are really good negotiators and get a good price for them, a lower price for the property. So there's a lot of variance that occurs in the marketplace. So it's not as precise as being able to add a column of numbers. There's a lot of considerations. And so that's why there's some leeway. It's not a dollar for dollar charge. They permit the government unit to ask for more than the appraised value, but not necessarily too much. It's got to be reasonable. So there are three components that make up any special assessment. And one of them is called a legislative power. And that's the power that's given to the state of Michigan when the legislators make a law, to a city when they create an ordinance. Somehow there has to be an authorizing statute or ordinance that permits special assessment to happen. When that exists and a jurisdiction decides to proceed, then people like myself or others involved in assessing undertake a ministerial duty. And it's their job to proceed with that special assessment as a levy, a financial levy. And then you have the confirmation of the special assessment, and that occurs first when the local jurisdiction, such as the township, approves the assessment roll. And then later, when there might be a judicial decision by the Michigan Tax Tribunal or the Court of Appeals that would also decide whether or not it was properly done. So 3 things: legislative, ministerial, and judicial. And here's one of the protections for taxpayers. And again, I really don't believe that a lot of people in government are aware of these laws, but this is part of what's known as the General Property Tax Act. It's been in effect for over 100 years now. And in the Michigan compiled laws, sections 211, 116 through 119, it says that if any supervisor or other assessing officer of any township or city shall willfully assess any property at more or less than what he or she believes to be true cash value, he or she will be guilty of a misdemeanor, and on conviction thereof, he or she shall be punished by imprisonment in the county jail not exceeding a year, or by a fine not exceeding $300. If you're a person who sits on a board, I happen to serve for many years as the chairman of a property tax board of review. And when we get new people on the board, I always remind them of these laws, because if their buddy comes in and wants to get an adjustment, a lowered assessment, and they try to persuade people to do that without justification, then they're subject to penalty also. And so we have, if any board whose duty it is to review the assessment of an assessing official or officer shall willfully assess property at more or less than its cash value, the members voting in favor of such action shall severally, in this case, severally, as I understand it, means individually, in favor of such action shall severally be guilty of a misdemeanor, and on conviction shall be punished by imprisonment in the county jail not exceeding 6 months and fine not exceeding $300. So here's one taxpayer protection. Here's another. In this case called Moulter versus the Department of Treasury, which was decided in 1993, the Supreme Court stated the authority to impose a tax must be expressly authorized by law. It will not be inferred. That means when the lawyers and the legal experts read that law and decide how to proceed, they can't add stuff to it. They can only specially assess what's in the law. And I'm going to give you an example later on of how that actually can impact a road assessment, and has in the past. Moreover, ambiguities in the language of a statute are to be resolved in favor of the taxpayer. So here is the term MICH, MISH, 443 MISH, means this is a Supreme Court ruling. So the Supreme Court articulated this point of view that if you're uncertain about something in the law, you have to make your actions correspond to being in favor of the taxpayer, not in favor of the jurisdiction. Now, I've worked in government for 30 years, and I can tell you that most special assessment projects are done because they're a needed public project. Nobody in the administration, or it's pretty rare to have somebody in the administration wants to run out and place a financial burden on a bunch of citizens who are going to be maybe electing them in the next, or not electing them in the next election, and who also are going to be angry and say something. So we have this type of language from the Supreme Court. Then we have another series of cases, plus the present State Tax Commission manual given to assessors uses this language. In Michigan, 2 guiding principles have developed to address taxation in general and ad valorem taxation specifically. In general, tax laws are construed against the government. So this goes back to the ambiguity. If there's any uncertainty, the government can't try to get the money from the taxpayers on hope. However, in reverse, where there's a tax exemption statute, those are to be strictly construed. And what that really boils down to is, assume that we had $1,000 that we had to raise, and we had 10 people paying $100 a piece to get that money from. And one person comes in and says, I'm exempt. I don't have to pay my $100. Well, then the other 9 people have to kick in money for the $100 that's missing. And so when somebody comes and asks for an exemption before the local property tax board of review or any other body that might grant that exemption, it's a requirement that the local unit of government interpret the law strictly. And that means the taxpayer's got to provide all of the evidence that's required and meet all of the criteria that are required under the terms of that exemption. So there's several important guidelines from the court that I share with the assessing community in my classes, and here I'll give you some of them. So cost is not equal to benefit. And back in 1897, Michigan's court said, assigning a fixed portion to taxpayers without regard to benefit is wrong. So you can't just say it's a $5 million project and we're going to spread $5 million on the people that live along the road or whatever else the special assessment is for. You must use facts, both known and ascertainable. This is really important. The term I use is less. Less means more. So you need to look at legal, economic, and scientific evidence. Now, I didn't bring you a quote from a Michigan Supreme Court case against the drain commissioners, but basically there is a case where a drain commissioner used their best judgment and decided to proceed with a multi-million-dollar special assessment. And the court said, you can't do that because your best judgment can't be your opinion. Your best judgment's got to be based on facts. Facts that could be known or discovered, known or ascertainable. And they comprise the legal, economic, and scientific forums at a minimum. Then if costs exceed benefit, the levy's got to be based upon benefit. So again, the Michigan Supreme Court 100 years ago said, sorry, if you're spending too much money, you can't get the excess from the taxpayers. They only have to pay based upon how much richer you made them. So there were 3 tests that permitted a special assessment, and that's why some of these laws or some of these decisions came about, because originally, or many years ago, beginning about 1929, the court had said that if you have a relief of a burden, say flooding, or you have a special adaptability, the groundwater is a saline, high salt water, then, and you put in a water line, you could specially assess for that. Or if there had to be an increase in market value. One of those 3 things justified a special assessment. Well, a major decision came down in 1993, this Codsbond versus Granville, in which the Supreme Court said, nope, we're sorry to tell you that it's only an increase in market value. All these other things provide some sort of benefit, but we know it as an indirect benefit. It doesn't affect the value necessarily, and consequently, you can't raise money based on anything but a measurable increase in market value to the property. So there has to be a reasonable proportionality between the assessment put on your property and the value increase. And in the beginning, there was a court case in 1986. The Dixon Road Group versus the city of Knol. And in that case, the court was looking at an assessment where and I'm making a number up to give you a ratio that's easy to handle. The amount of value increase through the appraisal process was determined to be, say, $1,000. And the jurisdiction said to the property owners, you owe us $2,600. Well, the court said, no, that's too high. So they invalidated that assessment. But in these court decisions, they don't tell you what is too low or what the right number is. They just tell you when there's a lawsuit, that number is not right. So later on, there was another Court of Appeals case in which the court ruled that if there was $1,000 of increase and the unit of government charged $1,800, that was too much. So now as assessors and administrators, assessment administrators, people know that they have to test what the determined benefit is and what the financial burden is. And if that ratio is off, you might as well can the project or find another way to fund it, partially or in full. So then a more recent case, this Aaron versus Bloomfield Township case, is important because most of us think about an appraisal as having a certain date, like December 31st, which is tax day in Michigan. With a special assessment, if you do that, you're going to lose your appeal. What you need to determine is what the value of the property is with and without the public improvement. You don't want any factors in there for inflation or deflation. So in summary, when a local government project makes real estate more valuable, the government may demand money from the taxpayer. Officials must act in a lawful way or be subject to fines and jail time. The assessments must conform to methods, processes, definitions, etc., that are described in the law. There's a thing called a presumption of validity that applies to the jurisdiction. The courts, as I understand it, as a layperson, say that we presume the assessor and all of the public officials did things lawfully. But it doesn't change the value appeal that you would have going before the Michigan Tax Tribunal in this case would be called a de novo hearing, which means there's no presumption that the amount of money that the government charged is correct. It has to be proven by both parties. And then I guess we're pretty much done, except for the Michigan Tax Tribunal did indicate that in one of its recent hearings that the burden placed on a taxpayer was 11% of the total market value of the property. And as I understand the language of that decision, the tribunal said the taxpayer never appealed that and didn't say that was an issue with them. But had that taxpayer said so, we would have acted on behalf of the taxpayer, because we think that 11% might be a little bit on the high side. So now you have two numbers, 1.8 times, and if it's more than say 10 or 11% of the total property value, it's questionable. And the reason that's true is because most of us realize that if you had a special assessment on a property in a subdivision, and 500 feet away is another subdivision with very similar homes, but no special assessment, then you may find that the buyers are going to go to that other subdivision, or if they want to buy a particular house with a special assessment, they may very well demand that the seller reduce the price or pay off the special. So an assessment that's too large can actually lower property values. And if that happens, then the assessment is illegal. So from an administrative point of view, for those who are government officials that are present tonight, there's a thing called the Declaration of the Necessity for the project. And this is a court case that came about in 1869. There's only 2 or 3 cases that I could discover over the years that I've been researching about necessity, but it's critical. If the unit of government does not declare the necessity for the public improvement, then the last sentence here is, this step having never been taken, the whole proceeding is nullity. So if that doesn't happen, the special assessment can be voided by the courts. And also sometimes they create the wrong necessity in their statement. There was a jurisdiction that approved a special assessment on a lake for some work, and they did it because it would keep a marina in operation. And the court said, no, you can't use public monies to benefit that private party. And so in that case, it was the wrong declaration of necessity, the wrong reason why. Then sometimes a government unit, going back to the idea that a government unit will say, this is the cost of the project and that's what the benefit is to the taxpayers. This is a federal case, so things don't happen just in the state of Michigan, they happen elsewhere. And in this case, in Norwood versus Baker, the court said the assessment was itself an illegal one because it rested upon a basis that excluded any consideration of benefits. A decree enjoining the whole assessment was therefore the only appropriate one. Basically, they meant they canceled the assessment because nobody considered benefit, and benefit is one of the 2 foundations for this law. And then here's another version of that. The requirement that the value of the benefit shall be assessed means that the assessor shall, from their knowledge, experience, observation, and judgment, make a fair and just estimate of the benefit which each particular piece of property will receive, by reason of the improvement. This is really important in terms of Public Act 188 because it's part of the procedural process in the law. An assessment proportional to the benefit and not to the market value or any other test is required by a statute providing that the jury shall assess against each parcel of land benefited its proportional share of the whole sum to be assessed. What that means is you can have a public improvement go through, let's say, a sewer line. And on one lot, you've got just a bare lot worth $80,000. And next to it, you've got a lot that's improved with a home that's worth $800,000. Well, the assessment, the benefit to each of those is to the lot itself and not to the lot plus the improvement. So you can't argue that a $20,000 assessment is appropriate because the home was worth $80,000. It's that $800,000. It's the $80,000 lot value that matters. Then we have two concepts to look at as we begin to look at how do you levy a special assessment. You have to determine this geographic area called a service district. And then you create the special assessment district from the service district. And there's two kinds of things to look at, two kinds of properties or benefit. One are properties that are indirectly benefited, and the other is a property that has that increase in market value. So you may have a property that benefits from a sewer line because the land drains towards the street and the water from the street goes into the sewer line, but the sewer line may be sanitary and a storm sewer combined. So the benefit from that is not from the land draining is not the same benefit that you would find in a sanitary sewer system. So in this case, which was a drain commissioner case in 1969, the court just simply said that there was a benefit, but it was an indirect benefit. And I just wanted to present this to you so you could make that distinction. Then we're beginning to look something about the roads, at something about the roads. And here we find, first, our Supreme Court has long held that the construction and maintenance of local roads is not a local concern, but a matter of interest for the state at large. And this was Morton versus the Secretary of State back in 1927. And there was a road commission, and they said, with less money, the road commissioners could not engage in as many construction and maintenance projects, resulting in a direct injury to the public in the form of bad roads. Although a lack of funding might hinder the county road commission's ability to fulfill their statutory duty to maintain and operate the county road system, it is the public that suffers as a result. Now, the important point of this is the at-large component. The court specifically said that roadways, once they're installed, are used by the public. So the damage that's caused to a road surface doesn't necessarily come from the person coming out of their driveway 4 times a day to go to and from work or to go to and from a school with their children. It comes from all the usage, the 20,000 vehicles or thousands of vehicles that traverse the road every day, from the frost heave, from a variety of things, freezing cycles. And so when that happens, those are at-large assessments, and you'll see that in these laws as we move forward. In this one, there was a question about how do you apportion these costs? So let's assume that the jurisdiction had a project and it had, say, $5 million. They took a look at it and they said, well, there's only $3 million of benefits. So at large, we're going to have $2 million. But in order to collect our $3 million, we have to be kind of creative in what we do in terms of how we apportion the cost. And that is, how do you place a cost against a piece of property? So here we had not just frontage on a street, but you had some charges for property that was some distance from the street. So the court said here that assessing a road pavement by either front footage or distance from the road, the trial court approved a distance approach. So the lower court said, hey, that's just fine. In affirming the lower court, we would establish precedent for a basis for an assessment that is not only difficult to measure, but lends itself to conjecture. Unscientific and subjective criteria would creep into any assessment procedure seeking to establish which lots receive more benefit than others. Such a sliding benefit scale becomes more difficult to use and arbitrary in its effect. Additionally, a basis for special assessment, such as that set down by the trial court, runs into uniformity problems because every valid assessment must be based on some legally ordained basis of apportionment and not be arbitrary. The benefits conferred by initially paving really are less dirt, noise, and mud, etc., which results from the new pavement in front of an owner's property, not from pavement down the street. So in this case, you had somebody that was being charged money because they lived away from that paved street. And you might think about how streets intersect if one is paved and or if two of them are unpaved and the intersecting road doesn't get paved, but the major road going by does. The people on the intersecting road don't necessarily have any benefit. That benefit was for the public at large. So again, you need to talk to your attorneys about this and use your common sense. So this slide is here just for your reference in the future. I just want you to know that there's that at-large component and there's the special assessment component and there's decisions that relate to those. And knowing, and the court said that knowing the increased value or benefit is critical to testing whether or not the assessment is reasonable. And that's that 1.8 times I told you about earlier. If you don't have a known increase in market value, how can you see if it's reasonable or not? So that's a challenge that any competent attorney would make in a courtroom. All right, here's an idea that I've thought of to kind of explain this service district and direct benefit. So what we have here are some commercial roads. And this one at the top of the green area goes to a lake, a little store that's about a half mile from the lake. And so people travel to the lake. And when they travel along those roads, they buy gasoline, they buy pizzas, they may stop and shop for other goods and things of that nature. So if you're a commercial property and you're located along the heavily, the red marked roads, then more than likely you're going to see an increase in the market value of your property because now you've got more traffic and presumably greater sales. And again, you'd want to document that with facts. However, down where it says indirect benefit to the lower right part, you've got a number of streets there and some of those intersect the red areas. They don't get any benefit at all. So your service district might include all of the red streets and some of the outside streets because they have more easy access and better travel times to work or schools or whatever, but they're not going to be taxed for what went on for the projects on the major arteries. And then the court actually recognized the importance of paving years ago. So in this Fluky versus the City of Plymouth case, which is 1960, they said the idea that road improvements automatically carry with them special benefits to a budding property may have been true once before communities had installed on a widespread basis impervious road surfaces, which could be used easily by automobiles. It was probably safe to say that every time such a surface was installed on a right-of-way for the first time, the adjacent owners were specially benefited. One cannot say the same about widening of a road in a residential district and its repavement when the previous impervious hard surface was amply adequate for abutting owners. In frontier days, and even today in some areas, the mere location of a road to or near one's property may confer a real benefit. This, in this case they were talking about, this is not such a case. This is not to say that the adjacent homeowners may not be required to pay their share of the cost of this new road in common with all other taxpayers. So they clearly said that a repaving is far different in terms of benefit to adjacent property owners than the new pavement was. I grew up living on a dirt road. I remember when it was paved and it changed a lot of things. Our water bill went down for washing and and my yellow bus. So another idea that just because you live on a road doesn't mean that you're responsible for the cost of improvements to the road. In Johnson versus Inkster, which was in 1977, the Supreme Court said, every public improvement is local in the sense that it's located in a particular area. Libraries, fire and police stations, and street improvements are all located closer to a property owned by some persons than to property owned by others. The location of this widened highway closer to plaintiffs' homes than to other Inkster properties does not by itself justify requiring a special contribution to defer cost. Once again, the Michigan Supreme Court said there are certain times when repaving may not be specially assessed, or if it is, it should be at a lesser value than a new road. So here's an example of where you might use a front footage and then maybe an area combination. So what we have here is a road, and on that road you have a number of lots with frontage that's pretty consistent with local zoning, but there's a couple of lots that have back acreage. And so the assessor in this case said, well, there could be a driveway put in, and it's feasible that the back lots could build properties. There could be improvements on the back lots, or the usage might be changed to some usage under the zoning laws that would permit a business to be back there, and for whatever reason. So the assessor chose to use front footage for everybody, and then assess the back lots with a per front foot or per foot square foot cost, or some other mechanism of that nature. Here's an example where you have many lots that are fairly similar, not identical, but fairly similar in size. Some of these large, the fatter lots with more frontage on the streets could be divided into 2 lots and resold. So in this case, the recommended apportionment method is by front foot, and because of the uniformity. And remember, there's a real distinction between determining benefit and apportioning costs. So benefit means a change in market value of a property. Apportioning costs means you found some way to fairly and justly spread those costs that are accessible amongst the properties. So below you see a cul-de-sac. And so in the cul-de-sac, there's all kinds of different frontages. And so in a case of this nature, the assessor would probably have a single lot assessment, which means that they would just take in per unit, say that everybody's going to be charged the same price. There's 12 people here and $12,000 of cost. We're going to charge $1,000 per parcel, not front frontage, because front frontage doesn't represent the way those lots are marketed. Those lots are marketed as lots, and it doesn't matter what the front frontage is. There's an advantage to a cul-de-sac. So to take a look at some existing evidence of value, I found a study from University of California, Berkeley. And this study said that they looked at a subdivision or 2, there were several subdivisions, where there had been gravel road and they were repaved. And the investigators found that homeowners felt that their property values went up 21 to 25% because of the new paving. Real estate appraisers said, we think it's 14 to 15%, but it's academic research that helps support or guide an assessor in determining how much value can, or how much of the costs can really be apportioned to the properties. And it's really critical, because if you're an assessment or an administrator for a unit of government, you've got a financial burden that you've got to deal with, and it's a really difficult thing. And special assessing is only one kind of financing. I mean, there's federal grants and there's loans and a variety of ways that one might finance a project, but there's no administrator that I know in charge of a jurisdiction or that would really say it's easy to find money to do these things. Everybody wants money from the same pot, but you still have to do it within the law. According to the same study, where unpaved roads existed within blocks having an urban population, proximity to newly paved roads increased nearby property values 3%. So you had a bunch of subdivisions and they paved a road that's a commuter road on the outside of the subdivision. You might see a spread of value of 3% to the properties inside, because then now the gravel road is gone and people can travel on a paved road and they like it. In 1960, we talked about fluky, so this is okay. All right. So when you're going to do your apportionment and when you're going to allocate the costs, you need to create this thing called the service district. And the service district merely means how is a property connected to that public improvement? Could be water drainage, it could be travel routes, it could be a variety of things. All the investigator is looking for is some legal, economic, or scientific connection. And it doesn't mean they're going to be assessed. It just means that somehow they're connected to that road or that project. And then when you go to look at your special assessment district, from that group of properties in the service district, you select the ones or identify the ones based on fact that have benefited financially. And there's got to be a separation of costs by the administrators of the special assessment. Costs that are unneeded or oversized infrastructure cannot be assessed to local property owners. So if the requirement is for a 6-inch sewer and they put in a 12-inch sewer because they know new subdivisions are going in a mile down the road, the taxpayers can only be charged for the cost of a 6-inch sewer, not the full 12. So the difference in cost between the installed sewer and what it would have cost if it was only for those property owners, that difference in price is charged to the local unit of government. Costs paid prior to formal initiation of a project. This happens once in a while where, in fact, I'm aware of a situation where a unit of government was a township, was going to develop a public improvement. They spent hundreds of thousands of dollars and the project stalled for some reason. And so then they later declared a new special assessment for the same purpose, but it was several years later. And they wanted to take the costs they had spent prior and add them on to the assessment to the property owners. And as I understand that particular case, the court said, no, you can't do that. It's got to be costs that were incurred when the special assessment was initiated by that a resolution by the jurisdiction and the finding of necessity. Then sometimes you run into a situation where a jurisdiction will want to pay costs. I'm familiar with the lake project where there was a tributary to the lake and the government officials decided that tributary needed to be cleaned out. And they took money from a lake fund and used it to clean out the tributary. And in doing so, then somebody objected and they had to pay the money back to the fund. You can't spend it outside of the special assessment district. To summarize the at-large cost for specially assessed, if it's oversized infrastructure, Michigan Adventure Company was one that had an existing sewage treatment plant, and the local unit of government attempted to charge them if I remember correctly, $680,000 for sewer line. And the courts ruled no, they've got a fully functional system. There was not $680,000 worth of benefit, so you can't charge that. So they invalidated the assessment. We talked about in Johnson versus Inkster, it'll be the next slide up, where there's damage caused by the public at large. You can't necessarily charge adjacent property owners. The expenses before the project is formally started are all at large. Expenditures outside of the district. And in some cases, in Tuscola County, Michigan, there was a township that wanted to put in some water lines and had spent more than $250,000 in this case. And they determined that the cost to the adjacent property owners was going to be $7,500. And this is a fairly long water line that went through both a village area and through a rural area. And it turned out that the Michigan Tax Tribunal had already ruled on a similar case where a water line went through. And in that case, they said the value increase was approximately $5,000. So this jurisdiction lost 1/3 of the potential revenue that they thought they were going to have. So it's really important to take a look at the activity in your area too. So determining benefit is a real estate valuation problem. It requires an appraisal, and the measurement of change value is not focused on any date. It's made with and without the public improvement. And if you intend to appeal an assessment, this is critical information to give to your appraiser, because if that appraiser does it without considering with and without, you're going to lose. Apportionment is the method by which costs are divided up or assigned to individual properties. The determining benefit is really a difficult problem for any assessor and any government unit, because you have to measure the economic impact on property from an outside influence, and it's hard to do. Determining values by class of property is important too. I showed you a commercial road assessment, and residential properties probably did not benefit from that commercial activity or the higher traffic volumes. If anything, their values may have gone down because there was more traffic on the road than before. It's really hard to find sufficient data for a market, so everybody should cut everybody some slack. You do the best you can and you try to be reasonable, but it's hard to find some of this stuff. It's important to separate the at-large costs properly from the individual costs, and it's important to know up front for any government leader that cost does not necessarily equal benefit, and if you proceed on that assumption, you may get burned. And then moving for the end of this and also towards PA 188, in the Court of Appeals case, it was said that the formula for the process is this: the township's got to receive a petition or receive other information which causes it to decide there's a need for a public improvement. The jurisdiction decides based upon direct benefit which parcels are designated for improvement in a special assessment district. The township officials review the petition and make sure that it meets the statutory requirements for signatures and things of that nature. The township establishes the cost of the improvement and creates a special assessment roll to indicate which parcels are to be assessed. And the roll is subject to public review and then corrected if necessary, and then confirmed by the jurisdiction. The township must determine what part of the eligible costs are to be assessed against individual parcels. So that's Cotterville versus St. Clair County. Now, for those of you who loved story problems and math, you're going to love this language from the law. Remember, I said that the plain and simple meaning of the language of the law is how you make an interpretation. But here's some legalese from the statute in PA 188, section 41.725. And the total amount, so what they're doing is they're describing how an assessor or a government unit should identify the amount of money that they can charge the public. And the amount to be assessed against each parcel of land, which amount shall be the relative portion of the whole sum to be levied against all parcels of land in the special assessment district, as the benefit to the parcel of land bears to the total benefit to all parcels of land in the special assessment district. Now, when I read that one, I was pretty confused, and I'm sure my cohorts were. Basically, what it means is you take the costs that are legally assessable and you create a ratio. And basically, you determine the benefit of each parcel in the district and you add those up. So you take the benefit of a particular parcel, say $1,000, and maybe the benefit for the whole special assessment district was $1 million, then, and your cost is $400,000. So you'll take and find that your the ratio is going to be 1,000 divided by 1,000,000, which is 1,000, so it'd be 0.001. You'd multiply the 0.001 times this $400,000 cost that I gave you, and that person would have an assessment of $400 based on that formula. So it sounds complex. When you break it down into math, it's not that bad, and it provides a mechanism. And you'll note here, this is from Public Act 188. So it's not necessarily a portion. In fact, I can tell you right now, it says shall. So you need to talk to your attorney for advice on this. But my understanding is that where the law says shall, it means you've got to do it that way. It's not may, it's you have to. And in this case, then you wouldn't do front footage and you wouldn't do a square foot. You'd take the value of each property and divide it by the total value of the special assessment district. And that will come as a big surprise to some people. So let's look at repaving a road under Public Act 188, which is the one I think you're proceeding under. Public Act 246, which can be used by the Road Commission to pave also. So in Public Act 188 and 246, both laws provide for paving new roads. However, in 246, it says at section 12, after the completion of said proposed improvement, the highway authorities having jurisdiction over the roadway involved shall maintain and repair said improvement and or sidewalk and shall keep the same in reasonably safe condition for public travel. My understanding of that portion of the law is that they can't reassess adjacent property owners if the first assessment was done under BA 246. And I do know of one township where I bumped into this, where the township was proceeding with an assessment. There was an $8,000 special assessment proposed for a small business. They said, we can't afford it. They hired somebody. That somebody wrote a letter to the township, asked their attorneys to investigate this particular clause, and the street pavement never went through because they couldn't do it under this act. Unlike your regular property tax, let's talk about the appeals and then I'll take questions. So unlike your regular property tax, a special assessment cannot be appealed annually. The financial burden is locked in place once the time for appeal passes, and the appeal window is really very narrow. And because the idea behind the special assessment is to get the job done. In your ad valorem property taxes, you can go into your local assessor and tell them they did it wrong year after year, and it's free. And then you can appeal for the Michigan Tax Tribunal for a few $100s and you're all set. Here, that's not true. Once that time goes by, it's over. So you've got to appeal within between 10 and 30 or 35 days, depending on the legislation you're dealing with. If your special assessment is authorized under Public Act 188, the appeal goes to the Michigan Tax Tribunal. If the appeal is levied under the Drain Commission, the special assessments levied under the Drain Commission, the first appeal, believe it or not, goes to the probate court. And if the special assessment is authorized under the state's police powers, then the appeal goes to a circuit court. So the Natural Resources and Environmental Protection Act that deals with lake levels, which is dams, is concerned about the public health and safety. And so if somebody objects to a special assessment there, they have to file a lawsuit in the circuit court and seek redress there. So I would suggest you look at the statute and call the Michigan Tax Tribunal to find out any appeal period before you take action, or check with the attorney. So that's the background information I wanted to provide to you. I have several questions here that were asked ahead of time. If the cost of a special assessment is more than the value of what the improvement provides within the special assessment district, will it fail? And the answer is yes. If the burden is more than the value, then they can only charge the amount, a reasonable amount related to the increase in value. And who provides the judgment on value? The assessor is the one who would initially set that value. Where are the legal resources a property owner can take if the township has proceeded without proper information or followed improper protocol? My response to you is that I'm not an attorney. I can't give you legal advice. I would remind you that there is a thing called the exhaustion of administrative remedy. What that means is that you have to appeal at every step before you can appeal further. There are variations. There's one variation I'm aware of with that. But you need an attorney to advise you for that. If an unpaved cul-de-sac road is off an unpaved road upgrading to pavement, but the cul-de-sac is not being paved, will the cul-de-sac property owners be assessed? Well, my immediate reaction to that one was that if it's a corner lot that may in fact benefit from the paving, you could say yes. If the driveway was clearly on the corner lot, if the drive was clearly on the paved road, then there would be a benefit. If there was no driveway access to the paved road, I'm not sure exactly how that would be handled, to tell you the truth, without looking at it a little bit. If a parcel is delinquent on their property taxes, can they be assessed for an improvement? The answer is yes. If not, who pays the share? Well, it's like any other property tax. You can lose your home for non-payment of a special assessment in the same way that you lose your home for paying non-payment of any property tax. So it would revert for non-payment to the county. And some counties have decided all tax reversions will be held by them. Others have decided it will go to the state. So it's going to go to the county or the state eventually, one way or the other. What can citizens do to stop abuse in SADs, special assessment districts, road improvements, and having to go to court for relief when there are issues? I think one of the things you do is have meetings like this where everybody's on the same page and has similar information. And then you would want to verify anything that I say with an attorney or somebody that's competent in the area of the law, discuss the procedures. Very few administrators that I know of want to go out and pick a fight with the taxpayer. So they're just trying to get a job done, and most taxpayers are willing to pay a fair share as long as it can be demonstrated it's a fair share. So that's what I would say, is try to become involved. And if you've not been involved in any committees like this committee here, or any other committees in your local unit of government, I'd very highly recommend that you sit on a board, whether it's a zoning appeals or property tax appeals or a road commission board or whatever. I think you're going to find that the people that serve their communities do it out of a sense of public service for the most part, and they really try to do a good job. So that's the end of my information. I'm willing to take any questions you might have.
I have one, Joe. So you made the point that if a special assessment district area had a road that had been paved and the people are coming back and they want to have the road repaved, we need to figure out if the initial special assessment district valuation was done under the Public Act 188 or under the 246.
Yeah, that's
So that
that's my understanding, but I recommend you talk to your attorney and verify that what I'm telling you is accurate.
But how, I don't know that we're gonna find it in the notes that it's going to say, we used Public Act 188 for the valuation of this property. Is there any helpful hints for trying to figure out how it may have been established initially? Because many times you're talking 10 or 15 years ago or more.
Yeah, my understanding would be that the jurisdiction had to have a declaration of necessity. And at that time, they would have described the special assessment district that's being proposed, or the idea of the special assessment, and they would have notified citizens. So it should be in the minutes of the jurisdiction.
Thank you.
Okay.
Oh, excuse me.
Thank
Linda,
you
are
for
you
your
talking about SAD like 20 years ago?
Well, so the follow-up on that, yes, but, so we've been talking about public roads, but we as a township are finding a number of private subdivisions that are privately held roads, not publicly held roads, that either are requesting improvements to their roads, again, now that the subdivisions are 30 years old and the roads have deteriorated. They're not public roads, they're private roads. Would the same ruling hold under the PA 188 or PA 246 for the initial?
Well, my understanding, again, this, I want to make it very clear. This is, you need legal advice, not Joe Turner advice. But my experience has been that if there is a private road that needs to be paved, that somehow you can't spend public dollars on a private road. So there may be some method of doing that. You could create some sort of like a tax capturing district. They could assist in borrowing money somehow, but you need an attorney. It's just my understanding you can't take public dollars directly and pave that road. I do know some jurisdictions have done that. They've made arrangements, but I'm not privy to the nature of those arrangements.
I have questions.
Okay, yes.
No, Jillian, you look like you're
Anybody
busy.
else from the committee have questions? Do you have any? No, not yet.
Yeah.
Not yet?
All right, Kathleen, can we? Couple of,
Okay, so what I got out of this presentation is the assessor must establish the benefit. They must determine what a property, their increased value. So what I interpret that is that this committee, the Road Advisory Committee, cannot determine the apportionment of costs. And I believe they have done that in the past. They have influenced whether it was based on frontage or, so is that correct? The assessor is the only one that can do the apportionment based on benefit.
Yeah, well, again, you need to verify your answer with an attorney, not with me, but my understanding would be that under PA 188, it's under the auspices of the township and not the road commission. There could be agreements between the road commission and the township, but the township is the authorizing body. And one of the provisions of the law, again, as I understand it, and I'm not an attorney, is that there are measures to make sure that government leadership doesn't expand the ability to tax people. That the statute that a township operates under was created by the state, and they can only act within the purview of the legislation that was created. So people can be very creative in what they do, and I'm not going to say that you couldn't make an arrangement that would work. It's just that there has to be something else. This is a law that comes through the township.
Okay, I have another question. I learned that the jurisdiction defines the district. So my question is, can a jurisdiction force an SAD on property owners simply by defining the district? And I'll give an actual example here. You folks are working with homeowners from Park Ridge. In this committee, there was the idea that Roseland Drive should be included in that district. I live on Roseland Drive. We never asked to be included in anything that Park Ridge is doing. So Joe, can a jurisdiction force my property into an SAD strictly because they defined who's included?
Was that directed to me or somebody else?
It's to you, Joe.
Again, these legal questions have to go to an attorney, but in all honesty, you have to look at if there's an increase in market value. If they're not paving the road, then there can't be an increase in market value.
But the question was, I'll restate it. Does the jurisdiction define the petition participants, or do those homeowners determine
Yeah.
who's
Okay.
in the petition?
All right. I'll give you a response on that one, but again, you've got to go to an attorney.
Okay.
I am aware of court cases where there might have been a challenge to a special assessment district. And to the best of my understanding, there's a thing called a presumption of validity. And that is that the jurisdiction operated properly. So if you were to challenge the special assessment district, you would have to pursue it based probably on constitutional grounds. And again, I defer to any attorney, but that would be, they have the right, they could create a special assessment district erroneously. And then it would be the job of the individual people apportioning costs to make sure that properties that shouldn't have been included don't get charged. So there's more than one resolution. If you had a special assessment district that was improperly formed and didn't have the money to go to court or whatever, you still have the opportunity to argue that there's no increase in your value and you shouldn't be specially assessed. So there's more than one approach that you could take.
Okay, and I have one final question, and this is specific to, if in our community, it's Park Ridge. What I heard from you is that widening the road may not convey a benefit to the homeowners. So simply widening Park Ridge does not necessarily improve their property values, and that before they proceed, there should be an assessment of the values before and after. Is that correct?
Remember, it's with and without. Don't do before and after, do with and without.
With and without, exactly. So
And the court in Fluky in 1960 said that widening a road doesn't necessarily benefit the adjacent property owner. So it doesn't mean, you have to consider the context of what's going on, but you have another argument. If you've got a gravel road,
yes,
and you're out in a rural area and you live there because you want the gravel, and somebody's going to come along and pave it, all of a sudden, if you take a look at the waterfall, the rainfall in the area, and you understand that the impervious surface, that tar or that concrete or whatever it's going to be, might cause friction with the tires. So you're going to get rubber running off onto the road. You're going to get gasoline, you're going to get oil. You're going to have all of that water that would have gone directly into the roadway being diverted to adjacent properties. So now you got an issue of pollution to the adjacent properties. Now, whether that's meritorious or not, I don't know, but I've heard the argument advanced. So it's not, all these things are not clear cut. It's every case is a little bit different. And so simply widening a road certainly doesn't sound to me like it does any benefit to, if it's an adequate road already, then it's clear it doesn't, in my mind, that it wouldn't add any additional value. But again, you've got to talk to an attorney. I can't give you legal advice.
okay, just finally, I am asking these questions because I see this committee just running willy-nilly, trying to satisfy a few members of the public. So Park Ridge, one person says, we want to do this, and you're off getting estimates. And then I hear that it's going to be expanded my road. And I'm like, what the heck?
That's not true.
I'm not done, Bob, please. I'm like, what the heck is this committee think they're doing? That I don't want my road paved. And then all of a sudden, oh, you're close to Park Ridge. Has anybody talked to one person on Roseland? Well, the one person you should have talked to was me, because the answer is no. I don't want Park Road. I don't want,
You have a lot of misstated facts there.
I don't think so.
I will tell you exactly what we did. After we're done with Joe, we'll have a discussion about Park Ridge, because a couple of things he said are just not true.
I see all my statements are true, so you would have to tell me.
We're
where.
not, there was never a discussion to widen Park Ridge. Matter of fact, that was the reason why we walked Park Ridge, so we wouldn't have to widen it. And I'm looking at the map here. Your street was never in the discussion.
Excuse me, Bob. Linda Smith suggested, did anybody talk to people on Roseland in meetings? She suggested that. The hair on my arm went like, what the hell are you guys doing? It was suggested by this committee.
Roseland was never discussed
Okay.
with Amy and Lisa and the WCRC.
Linda Smith brought it up. She tried to expand it.
That could be one way of looking at it. Yes, Jillian.
Could we go through the questions and then
Yes.
we'll get back to these?
Do we have any other questions from online?
Oh, yes, we have more. Kim Phillips Canope, let me unmute.
Can you hear me?
Yep.
Okay, great. So first, I'm really appreciating the presentation and listening to it. It's clear that the township acted inappropriately and put themselves at legal risk in the SAD that was proposed in our neighborhood. Honestly, I think Scio is lucky that residents prevailed in like the SAD not going through, because if it had gone to court, it seems really clear that we probably would have won, and it would have cost the township a lot of money unnecessarily. Let's see, our neighborhood was harmed greatly because our SAD was mismanaged. There was a strong pro-paving bias from the township, and the township ignored its own guidelines and got way ahead of itself. They commissioned an engineering study before a resident petition was even submitted. When residents were finally surveyed 2 years into this, 82% were strongly opposed. In our research, we talked to the Michigan Township Association, and they told us that many Michigan townships are refusing to do SADs at all because neighbors can be pitted against one another, which happened in our situation. There can be a heavy financial burden, and that the township can sort of become at odds with the community itself. I'm wondering, how should our township assess whether we should even be doing SADs at all? I have one other question that goes along with that. In our township, we have volunteer, quote unquote, SAD expert advisors. They've been counseling pro SAD residents, advocating behind the scenes for paving, and even soliciting paving SADs within neighborhoods they don't even live in. Should townships allow this? And how can residents be assured that the process is unbiased and based solely on the interests of those directly involved? Thank you.
Jillian, what neighborhood is she from?
Railroad Street,
Thank you.
the Glade.
Thank you.
Joe, did you catch those questions?
For me,
Yes.
Yeah.
I really think that those questions go to the attorney, not to me.
Okay, so,
I would really appreciate your expert opinion, Joe, about how townships determine whether or not they should even be doing SADs at all. Like, what are the things that they take into consideration? I don't think that's an attorney question so much. It's just providing sort of guidance for how townships can determine whether they even want to be in the SAD business or not.
The law clearly provides that a township can move forward with a special assessment for a variety of purposes. And it's a very large list when you look at PA 188. So there's no question in my mind that a township can, and they do all across the state. I'm not aware of any township that wouldn't do a special assessment district.
I'm not suggesting they can't do it. Our conversation with the Michigan Township Association told us that there were many townships that choose not to do it because of the conflict that it can cause in the community.
Oh, they're more knowledgeable than I yield to them.
Do you have any experience with my second question about people sort of outside advisors, people who are outside a neighborhood advising and soliciting community members that were in neighborhoods they don't live for SADs?
Well, I think it's fairly routine to have advocates for special assessment districts. It sometimes can be disconcerting to some individuals that don't want it, but it's part of the public process. People, you have a petition that can be signed, and that requires people to get together and decide whether they want it or don't. And then you'll have the debates that go on, and you're going to have somebody who will rise up and be an expert in their own field. So I think it's a common practice.
Kim, are you finished? Oh, yes, she is. Okay. David?
Yes, thank you. Thank you, Jillian, for organizing this, and Joe, thank you for coming. My name is David Reed, and I had submitted some questions to the committee for you, Joe. Many of them have already been answered, and my questions really concerned an SAD for a private road where the residents who live on the road have petitioned the township to pave our road. And I know you said public funds cannot be spent on a private road, but the way we do it in Scio Township, right or wrong, is that the township fronts the money to pave the road and then collects it back over and gets it back from the residents over 10 years through apportionment to their property tax. Whether that's right or wrong, that's how we've been doing it. But a couple of my questions had to do with benefit versus cost. But I think, and correct me if I'm wrong, Joe, if the residents of a street are actually asking a township to pave the road and they agree to the cost beforehand, then whether the benefit is equal to the cost is really moot point because we agreed to the cost. Is that pretty much correct?
I would agree. If under the circumstances that you've described, you wouldn't have anybody that was complaining.
Right, okay. And so several of my questions are null and void there, Jillian. One question I do have though, and we've done things, when we first started doing SADs 10 years ago, maybe a little less, the township actually started paying for the engineering costs when neighborhoods did not go forward with the SAD that they requested through this whole process. The township then changed and actually started issuing a special SAD to pay for the engineering costs and then a second SAD to pay for the paving of the road if the neighborhood went through with that. Reading Act 188, it's kind of as typical of the law. It can be interpreted several ways. The very first statement in Act 188, the very first opening paragraph says that the engineering cost is part of the improvement. And later on in the document, it says that the SAD can be issued for any part of the improvement. So one could say that one could interpret that say that the engineering cost could be put through an SAD or could be charged via an SAD on its own. But the question is, if the actual improvement of the road is not done, is it legal? Well, again, is it correct for us to do this separate SAD for the engineering cost versus the actual paving cost?
Is that directed to me?
Yes.
I would say the criteria is an increase in the market value of the property. So if the engineering cost just merely benefited the township or the jurisdiction and it didn't cause an increase in the market value of the property, I find it hard to believe that it would be sustained in court. I don't know. That's a lawyer's question.
Right.
Caution.
I understand. So we may be skirting, well, okay, never mind. I think that
Why
was
wouldn't that be folded in? Why wouldn't that just be folded into the special assessment?
So here in our township, it takes sometimes a year to go from the engineering to the paving. So especially if we do the engineering in July or September, then we run out and then the asphalt plant's closed and we can't do the paving until the next year. So we hope, we would like to have everything done within the same season, but that sometimes doesn't happen. So here they have $5,000, $10,000, $15,000 worth of engineering costs that have to be paid.
Yeah. Can you arrange an agreement with the county or with a bonding agency to float a bond to cover any of that? Is it too cumbersome?
Bonds are a four-letter word in South Township.
All right.
I suppose we could, but people are not real. I think township, the board is not real, does not look, my opinion is the board does not look favorably upon bonds because they can be very expensive to get and to pay for.
Maybe it's time to set aside a little money in the budget to anticipate some of these. 15,000 is some money, but it's not terrible.
Right. But when you have 3 or 4 of them in a year,
Yeah.
it starts to add up.
Yeah, I get it.
Yeah, and we have done, I think this year, I think we did 3 or 4 SADs, private road. Well, where there's 3 private roads and 1 public road, I think.
Hmm.
So it does mount up. All right.
Yes, so David, just to piggyback on what you said, there's one neighborhood that decided after the engineering not to move forward because it was way too expensive and they were still charged for engineering. So from what I'm hearing you say is that can't be done because it's not the improvement. It doesn't bring a special benefit to those properties, which is an increase in value. Or is that a legal question?
Yeah.
Well, if I was involved in that project and I had these kind of offers coming forward, again, talk to your attorneys, but I would set up I would declare a special assessment for paving the road. And then If the special assessment fell apart because the petitioners no longer wish to do it, you may very well have an opportunity to specially assess them, not in a separate SAD, but in one SAD that was designed and initiated based on the premise they wanted it. And if they back out, then you might be able to recover costs.
Kathy, go ahead, and then we'll.
Okay, I have two questions for you. Are you gonna give us each access to your PowerPoint?
It's my understanding it's recorded and it'll be there for you anytime you'd like to see it.
Okay, but I meant like email it to us, or so we could just print it out. Are you planning on doing that?
Well, no, I thought that the meeting would take care of that. Who am I speaking with?
Kathy, Knol.
Okay. You're a part of the committee?
Yes.
All right, I'll make sure. I use, I'm not using Microsoft software. So I have to zip the file and make it an executable document. But I'll make sure that I send something to Jillian that's updated.
Okay.
She has a version, but I've changed it. So you'll get the updated version.
Okay, thank you. So I have a very general question. I think you're aware that we have a township-wide SAD. And it will go for 10 years. Each residence contributes the same amount each year. Have you looked at that? Did you review the language in that? Do you have any opinions on it? Because I'm wondering, given this test that you talked about, reasonable proportionality, I'm wondering how that fits our current SAD practice township-wide.
Well, that's an interesting question. Yesterday, I was in Northwestern Michigan discussing special assessments in a class with some public officials in addition to assessors. To the best of my knowledge, a unit-wide special assessment would be very difficult to implement properly. They're used with a millage rate where there's a vote of the people. And if there was a vote of the people for this particular special assessment, that might change conditions. But if it was initiated and there was no vote of the people, but it was initiated by government, again, you need an attorney, not me, but I would be surprised if it was not subject to challenge.
So what would the difference be between a special assessment and a millage then?
Well, that's what's happening is 1958, St. Joseph Township wanted to put in a fire millage. And for the first time, the Supreme Court allowed a unit-wide millage, a unit-wide special assessment with a millage rate. And it was done specifically with the argument that how better could you finance a fire department? How more fairly could you finance a fire department than charging an assessment based upon the value of the property being protected? Now, what happens if you have vacant lots? How important was the fire department to those? But nevertheless, it's my understanding that broad principle has been challenged and that the initial decision of the court had been modified somewhat by those challenges. But again, I'm not competent to address that issue because of the legal component to it. But I would be reluctant to engage in what can I ask? What's the nature of the special assessment? Why would you do it? Why?
The township-wide road special assessment is $85 per parcel to fund the connector roads, to maintain their connector roads.
Well, you need to talk to the attorney, but I'm hard pressed to believe that there's an increase in value of all properties. I showed you a slide where it was true that there was a 3% increase in the value of properties, according to one academic study. But remember, roads are used by the public and they're damaged by the public. And so if somebody lives 5 blocks from the connector road, It's not likely they're gonna, then they have a variety of paths to follow. You know, it's just a complicated area and I have personally have trouble with it. I yield to the attorneys on that one.
Okay. And would, after a special assessment is approved, the amount, I guess, or the, can money be taken from that special assessment and placed somewhere else for a project?
To the best of my knowledge, again, it's a legal question, but absolutely not. The money collected for a special assessment is there for a public improvement that was documented. And it's only, you can't just start to replace your budget with a special assessment. It doesn't work that way.
Okay, Kathy, are you finished with your questions? Or do you have more?
I'm okay, I'm done.
Okay, William Bogan is next.
Unmute and start. Hi, we're Bill and Cynthia. Oh, put a background on us. Anyway, okay, yes, I have a couple questions. I'm very glad you're here speaking, Mr. Turner, because I think I'm glad to have these questions answered. Let's start with this one. How long is a SAD petition valid?
Oh, I don't know the answer to that question.
Okay. Do all SAD plans have to be filed at the township hall?
Yeah, if you take a look at PA 188, there's a portion that deals with the having documentation in the clerk's office.
Okay, so what happens if SAD is not completed?
Well, that's what we talked about earlier. If you have a special assessment district, it's initiated by the township. Now, again, you're getting into legal issues and I really can't tell you the law. But
Yeah.
what my understanding from my experiences have been that where there's a special assessment that was initiated and then it was discontinued for some reason, if there's a possibility that the cost and the burden would fall back on the unit of government, if it was initiated by the unit of government. If it was initiated by private parties, it may very well be that there's a mechanism that assessment could continue to recover the costs the government spent at the request of the private parties.
Okay, what township official has the responsibility to be sure that a SAD is completed as it's written?
Well, I think it's the trustees. I think it's your township board.
Okay, so
They confirm it. If you look, again, what you need to do is go back to 188 and go right through step by step through the law, because they outline exactly who's supposed to do what.
okay. Is it in road committee representatives presenting a SAD as it only starts the ball rolling, it's not a commitment? Would it be, is there a legal requirement for a public meeting before a neighborhood can be assessed anything based by the township based on a SAD?
I cannot answer legal questions. I'm not competent.
Okay, so in other words, it falls upon the homeowners to hire a lawyer to find all these things out if it seems like there's been irregularities and SADs?
Yes.
Yeah, that's a little bit of a hard pill.
No, it's not. I mean, anytime you have a dispute with somebody, you need competent legal advice. And the lawyers are the competent legal advice.
Okay.
Hopefully.
I know it's expensive, but that's the way it works.
Yeah, so I can tell you that our neighborhood, Liberty Hills, was one of the ones that there was no public meeting and it was simply presented to the board. Can we make road plans? And it was approved by the board and there were no, it's never happened, but okay, that's just our situation. All right, is it legal to if you have drainage issues, is it legal to be looking at paving without addressing drainage issues?
Again, you've got a legal question. I cannot give you legal advice.
Okay.
Okay, I'll throw in a question of my own. So determining when residents vote on a SAD, like we're in Liberty Hills and it was based on frontage. You know, your vote was weighted by your frontage. And the benefit was somebody, we don't even know how the benefit was calculated or who calculated it. But the assumption was that everybody benefits equally from the paving, even those that live, 100 feet from the main road or 1,800 feet from the main road, on what is now dirt. That's something they all can benefit. But the cost was assigned equally per parcel. So it has seemed very unbalanced that people with greater frontage got a greater vote, but didn't have to pay any more than the guy that had small frontage.
Well, you raise a really interesting question. And I wanted to point out clearly in my presentation, and I'll repeat this. The statute that you're operating under, 188, has a very specific formula for how costs are to be apportioned. And the language of that is shall, not may. And so if in fact your lawyers would agree that that language controls, then front footage doesn't mean anything, acreage doesn't mean anything. It's the value that the property had based upon the increase in value based upon the increase of the entire district. There's one measure that's in the law.
Right. No, I noted that when you said it, but that's cost versus, value increase. I'm talking about the original vote on the SAD to make the SAD happen. It seems disproportionately based on frontage, whereas cost, is evenly proportional to, well, whatever, it's based on your valuation.
Yeah, again,
It's apples and oranges.
Yeah, now you have a political element where people voted in such a way because they were convinced of one thing or another. That has no bearing on from my perspective as an assessor. It's either approved or it's not approved, and it doesn't matter why, why somebody made their decision. Once they make the decision, it's made. As long as it's.
But somebody with 4 times the frontage or 10 times the frontage has 10 times the vote. It just seems.
Well, not here, because remember I said under the law, frontage doesn't matter.
It does for getting
It did in our
to
case.
get the SAD going. That's what
The petition was weighted by.
Oh, I see what you're saying. Okay. I don't know. I can just tell you that if they were persuaded, they were persuaded. It's just you follow the statute.
But I guess there's 2 parts of that. It's whoever is representing the township should be representing upfront and legal, not just kind of doing the pull the wool over the sheep's eyes thing. And do you have a recommendation for a lawyer who knows about that? And I mean, Jim
I understand your
shouldn't
question.
Jim Fink be getting in there?
I understand your question, and no, I don't have any recommendations. I actually came here to be a neutral party and try to answer your questions as well as anybody else's that work for government.
And we appreciate it.
Well,
Yeah.
Okay, thank you.
okay, you're welcome. Thank you for the questions.
Next is Steve King.
Okay, thank you. Took me a minute to unmute. Being a neighborhood that has been assessed for a SAD 2 years ago, I'm curious as to how we can potentially try to find a way around that, because when we went through the SAD, the previous administrator and the rest of the board of trustees gave us advice that somebody brought it up, it's like, we want to do a SAD. We're on a gravel dirt road. And when it came down to advice, we were given advice by a certain person that said, oh, it's only going to be $10,000. It turned out to be almost $17,000 per property, 22 properties. And when it came down to it, more than half of the participants voted no. We needed more than 80% to vote yes. So when that came through, we were led to believe that we were not going to be charged. And when we got taxed, it was over $800 per property, of which at least a half a dozen were retirees that had to pay an extra $800. So I'm curious how that can be addressed, as well as the entire township SAD, which to me seems like a slush fund. or doing things that are not improving property values, that, I don't see that a township SAD does anything for my property value, being on a dirt road. I'm on a connector road, which is done. So I'm just curious about what your thoughts are about that.
Well, again, I caution you that I can't answer legal questions.
Understood.
I
got that.
certainly think that we've seen experiences where township officials have been held to account for activities they undertook, which the voters didn't care for, but that's as much as I can comment on the. I see where you're coming from, but that's in the past, and to rectify it, it's going to be expensive, probably, and you need competent legal advice in these issues.
And you've said competent legal advice at all times. However, when the residents are the minority and have to raise their own funds while the township and the Board of Trustees has many lawyers working for them, I'm wondering, where's our recourse? Because now we have to find a lawyer that's going to help us work against things that did not work for us done by the township.
Yeah.
I'm really worried about that because I have half a dozen neighbors that are retirees. I'm not yet, but they've had to pay fees out of their own pocket, which was expensive, and it hurt them financially. And I have that concern.
I wish I could give you better news, but I'm aware of a situation. I was called to a meeting in a township where there was a drain that went in. And there's this little old lady who's about 80 some years old, 85 or 86 years old. She lived on a farm. She was a widow. And there was a drain improvement to protect a commercial district in a jurisdiction 5 or 6 miles from where she lived. And in the meeting, I had to tell her that the time for appeal had passed. And I said, how much was the special assessment? And it was $25,000. And she had no way to get that money. Finally, her grandchildren said that they would kick in and help grandma. So she's a very stoic lady. She's got a tear coming down her cheek. And then I turned to the couple that had invited me to that meeting, and there was a member of the state representative there. There was a member of the county board of commissioners, and these people said, yeah, we had a special too. And I said, well, how much? And they said, now these are all farmers. And they said $70,000. I said, how are you going to pay that? And they said, we paid it. And I said, how'd you do that? They said, we took our life savings and paid it. I said, do you know of anybody else? Yeah, down the road, there's a young couple with a couple of kids, and they had a $35,000 or so special assessment. So when these laws are done improperly, or when there can be honest mistakes. It's not because people are always nasty. They're just sometimes unaware of things, no matter what capacity. And I have great sympathy for some administrators, because it takes a lot to run for an elective office, to sit in there and have people question what you did and believe that you're not a good person. And when you try to, and there's a learning curve that's huge. But in this case, I was very aware of the damage that was caused to those people, and it wasn't rectifiable unless somebody changed the law itself. And so that's why I'm not trying to avoid questions. It's just that that's way beyond me. These are legal questions based upon harm that was caused, or potential for harm, or perceived harm. And I can't deal with that. I'm not in a position to do that.
And I appreciate that, being the businessman that I am. And I'm glad that you're the one expert we have here, because I mean, honestly, with a lot of the different SAD activities we've had throughout the township, including the township SAD that is out there, a lot of residents that I've talked to, including all the ones that are in our neighborhood, really feel like this has not done us well. It's done us a disservice. And putting us on the public record about what we need to do is very important, because we have to watch our government. We have to make sure that they're working for us. And when these things come up, and they come up far too often in the last couple of years, we need to know what our recourse is and how to address it. And I appreciate your input.
Thank you.
Jillian, who else do we have?
David Reed, did you have another question? There's a couple more people that are in line.
Well, I can wait till the end. I just had a comment about the township-wide SAD and what its purpose was, but I can wait till the end.
Okay. Yeah. Let's see, Paula Paula's iPhone. There we go, there we go.
Hi, Jillian. Thank you, Mr. Turner, for giving us this presentation about benefit, how a SAD benefits the public. I'm asking about a particular proposal that is basically going to be a connector road to off of Zeeb Road, which is a more major has become a more major connector road. So the idea is this developer has agreed to pave a portion and is going to stop, and then there's two neighborhoods, subdivisions on each side. Now, from talking to the people in my neighborhood, I haven't talked as much to people in Country French. People are not for it. And this is a township initiated, and basically it's going to be a cut through. They've put a roundabout, and they're allowing a developer to develop a portion of land that people that live next to it, that are some condominiums, feel they're going to be flooded and there will be extra traffic. Basically, it's going to be a cut through at high speed, and then go around this neighborhood and then out to Jackson Road near Menards. And right now it's a proposal. So first question is, I hear you say we have 10 to 30 days to initiate. Now, is that only with the tax tribunal? Or is that also with, I'm not sure when you bring in a circuit court? Because there's no benefit to the majority of the people, and most people have no frontage on that road. Now, there's some people on the road commission who actually own property, and I think she is the head of the road commission meeting here, who definitely would profit from having that road paved, because she has quite a few acres that could be developed, and has developed different property down Liberty Road. And I look at it and I go, there's no benefit for us. And so I guess that I look at the legitimacy of a person who is leading, who also, I had a freedom of information that states she wants to work out of the supervisor's person. And I think this goes back to the question of the couple, that when the township is the initiator, and if the work isn't done, then people are they still stuck with paying the engineering when they don't? Because in this freedom of information, it says, oh, there's a person in Country French who we need to talk to that person because they have road frontage. So I'm a bit confused. And they want to work out of the current supervisor's office. And then it's going back to Steve King, I believe, or maybe it was Kathleen Brandt's question. When you have a person who used to work on the Washtenaw Road Committee, who says he's knows all things roads, who actually lives on a dirt road, putting a lot of input into this proposal. These may be all legal questions, but the main thing for you is, if there is no benefit, because we have an entrance that goes out to the road, we don't use the one that goes out to the dirt road. And I look at it as it's going to become a cut through, possibly more dense development, because they want to give a density bonus to developers. I look at it as it's going to have double loaders dragging gravel down it going 45, 50 miles an hour and actually really increasing as a cut through. And I thought it was interesting because I read an article on the Scio View that Washtenaw Road Committee Commission had wanted to put a road through Scio View from Liberty to Jackson. And Mr. Hathaway, I don't know if he was a supervisor then, but said, once you get a cut through, it's very hard to put the genie back in the bottle. And I look at like these two neighborhoods are not the people who are initiating this particular SAD.
Paula, excuse me, I'm going to interrupt. Paula, so what I'm hearing from you is your question is about direct benefit, the direct benefit that a special assessment district will provide for your parcel.
Especially when it isn't initiated by the two neighborhoods that they're going to try to collect per parcel.
Okay, so Joe, again, what is a benefit again?
I think that if it's a gravel road and it's going to be paved, there may be some benefit to adjacent property owners. We do know that. I think it would be wise to invite a real estate appraiser or several, maybe to discuss roads. So what you need are facts. There's a lot of people that have a lot of questions. And while I've described the process and some of the elements that go into deciding how to apportion property, this law is pretty specific in the way they want it to be done. And I think it would be very helpful to invite in a member of the Appraisal Institute or somebody else to do something similar to what I said. And that would be to describe what the values might be from these projects to adjacent properties so that you can proceed with knowledge, economic knowledge.
Okay, so a public benefit versus a direct benefit versus a special assessment benefit. So a public benefit would be the public at large benefiting from a certain project.
Sure, and these roads, as it was described here, that would be primarily a public road that would be conveying traffic to a commercial area. And so the real issue for everybody that's a citizen that's going to have to pay is how much did my value change because of this public improvement? I've got to tell you, I've got an appointment coming. I've got to leave in just a bit here. So.
Okay. Yeah, thank you, Paula. We have two more questions or two more hands and that's it, unless there's somebody else.
Okay.
Let's see, Jonathan, it just says Jonathan Guest.
Hey, this is Jonathan. Thank you, Jill, for setting this up. Thank you, everyone, for the good questions. In listening to the conversation tonight, it leads me to a two-part question. First of all, are you an attorney?
No, I've made it very clear. I'm not competent to give any legal advice.
And secondly, I was going to ask you, are you competent to give any legal advice? I'm sorry, Joe, I really appreciate you showing up and taking all these legal questions and being such a good sport about it. Thank you very much, and I'll let you go.
Yeah, well, thanks.
Rob Pattinson.
Ryan Yapple had his hand up long before I did.
I'm sorry, it's just, they're popping up and the names are in order. So I'll go ahead with Ryan then.
Yes, please.
Okay, sorry.
Thank you, Rob. Thank you, Mr. Turner, for coming tonight. Appreciate your time. I have two questions. One, and once again, if you don't know this, feel free to say it. If a property owner purchases a property and there's 3 years, for example, left of the special assessment that's assessed yearly, should they have to pay the entire remainder of the assessment at the time of the property sale? Is that normal in your experience?
As I understand your question, it was if there's a special assessment levied and it's levied in periodic payments at the time of the sale of the property, does it have to be paid off in full?
Correct.
All right. Again, that's a legal question that I
Okay.
can't respond to.
That's fair.
I have heard of that, but it's a legal question.
Okay, not a problem. I appreciate it. And the other question I was going to ask, which I think you can speak to a lot more. Certainly, I think you gave a lot of great court citations. We can go back to look for competent legal references and potentially people that specialize in this area. But can you explain a little bit more about the administrative appeal process? You said that was necessary to exhaust before we could go through a legal appeal with competent counsel.
Could you repeat your question for me, please?
Yeah, earlier in your presentation, you had mentioned that before you can really go through a legal appeal of any sort for a special assessment district, you would need to go through an administrative appeal. I would figure appealing either with the township board directly or with the assessor about the assessment. Could you explain, at least from the administrative side, from the local government side, how that process works?
Yeah. Basically, I would encourage you to read the statute for yourself. And again, this is a question where you need to talk to an attorney to make sure that you understand that process. But having said that, my experience in assessing has been that there's a principle called the exhaustion of administrative remedy. And it means that you need to appeal at the correct opportunities. And if you don't, then you can no longer, your appeal terminates if you miss something. So before you can go to the Michigan Tax Tribunal, some laws require you to appeal to a local board of some sort. And there are hearings that will be held under PA 188, and you need to go to those hearings and express your opinions. And again, you need to confirm this with the attorneys. It may very well be that in some of these administrative hearings, what you're going to do is it's just an opportunity for the taxpayers to voice their opinions. And then the administrative board or the administrators will make a decision. And again, I'm not an attorney, but as I understand it, there's a presumption of validity that goes to the action of the board. And what that really means is that they're assumed to have behaved lawfully. And so once they hear these objections, even if they fail to act on those objections, that it's still going to be considered to be a legitimate special assessment procedure, unless you can show there's fraud, error of law, or a couple of other items that the attorneys would be more familiar with. But there has to actually be a violation of the law or constitutional rights, et cetera, before that would be invalidated.
Excellent. Thank you very much.
Okay.
Okay, the last hand is Rob Pattinson.
Hi, Mr. Turner. Rob Pattinson of Scio Township.
Good evening.
First question. Can we write to you with some of our questions tonight? I understand you need to leave. Will you be willing to let us write to you and ask those questions?
Well, I'm going to be gone. I'm traveling a lot. So the answer is probably no. At least for the near future. I'm going to be gone for, I just recovered from some surgery and I'm going to be gone for a while here. So maybe in October I would consider something, but I'm not, I am a professional and I do get paid for my time. So there might be that issue that we have to talk about.
Okay. Listening to your presentation earlier tonight and answering some of the questions, from what I understand, that the very first thing that needs to happen in the SAD process is a petition to either come from the neighborhood or the beneficiaries of the road paving project, and that or a township initiated SAD, that the very first thing that needs to happen is that the SAD needs to be established before engineering, before anything else, because it's the SAD that is your guiding process. Is that true?
Well, again, I'm not an attorney, but I read the law the same way that you would, is that The initiation of the process comes through the township, and they have to indicate to the public they intend to proceed with a special assessment and the method of authorization, whether it's by petition or whether it's by their own action. And then following that, they have to declare there's a public necessity, and then you have all the steps. So, but again, verify with an attorney.
Okay. And then in Act 188, are all of the appeal timelines, are they already established? And will our roads committee, because what's happening in Scio Township is our roads committee is putting together their policies and procedures for how the SAD process works here. Are all those deadlines outlined in 188, and will our roads committee be able to establish those within their policies and procedures?
Yeah, again, you and I can read the law, but we're not attorneys. But here's the deal, as far as I understand it, acknowledging I'm not a lawyer, that there are going to be specific guidelines and there are in the statute for when hearings are to be held, when complaints are to be given, things of that nature. The one issue is going to be, this is a special assessment being administered under the general property tax laws of the state of Michigan, which means the appeal goes to the Michigan Tax Tribunal. And it's my understanding today that the Michigan Tax Tribunal will accept an appeal within 35 days of a final decision. So in this particular, and again, verify this, make sure you call the tax tribunal or talk to a lawyer, but 35 days should be your number.
All right, last question is we have a DDA and they have subsidized a couple of SAD projects. And have you seen that process in other townships? And does that establish a precedent for all following SADs that they would need to be subsidized at the same level?
Two parts to your question. First of all, let's make sure I understand. You're talking about a downtown development authority. Is that true?
Correct.
Okay, that was for those of you not familiar with it. The Downtown Development Authority is an economic development law. It was developed about, I think, 1974 and 1975. It was the first of the modern economic development laws. And the theory behind it is that you will capture taxes from a project. So let's say that you have a bare piece of land that's worth $50,000. Somebody buys it because it's in a blighted neighborhood and they put $1 million building on it. Now you've got a new tax that's going to be $500,000. So what you'll do then is you're going to capture those taxes, and that money that's captured, so the property owner pays the taxes just as though nothing was there. It doesn't matter to them. It's transparent. They can't even see a difference in their tax bill. But when the money's gathered under the DDA program, a portion of it is used for DDA expenditures. And that's a very creative way to move forward, because what you've got is, if there's no development, there's no capture, and there's no loss to anybody, the tax base is preserved. If there is in fact a development, there's a new stream of tax revenue, and that money can be used to improve the community. So I don't have any problem with the DDA paving roads and then collecting money for that pavement from the participants in the DDA. Does that answer your question?
That's close enough. Thank you very much for your time.
Okay.
Okay, I'm sorry, one last hand, it's Deb. And that's it.
This is it.
Okay, there's.
Okay, I'll be quick, and thanks, Joe, for helping us with this. I understand how costs of an SAD must be apportioned, but when one is getting considered, let's take a simple case, parcels with road frontage. Is it correct that approval of a SAD can either be one parcel, one vote, or it could be structured so that it weighs the votes by amount of frontage? And then part two is, does that differ if it's a township initiated versus citizen initiated?
Yeah. Okay, this is another one where you've got to talk to an attorney. I'm not competent to interpret the law for you. And so I would recommend you read the statute very carefully, and it's gonna answer your questions for you in general. And you may want to sit down with somebody. The other thing I would caution you as a group about is that while I've given you the language of the statute with regard to benefit and how it's to be computed, it has been fairly commonplace. In fact, it's been very commonplace for people to apportion property or special assessments based upon front footage and based upon acreage and based upon units. So consider that carefully. And again, seek legal advice as to whether or not the apportionment method is something that should be challenged or could be challenged. And with that, I just want to thank you for inviting me. This has been a very interesting group, and I certainly appreciate your questions. It is very helpful to me. I've been involved in the business for 50 years. And so I enjoy these interactions with the public. And I just sincerely appreciate your local officials inviting me. And I will tell you, I would encourage any of you out there who feel motivated to join in some committee or some way with your local volunteer, with your local community, because we need that all across the country. And I think your eyes will, you'll be very surprised by some of the things that you run into in terms of how hard people work and how dedicated they really are. There are misunderstandings, and there are sometimes people just bull their way through, and that's not right. And we've got money at risk here. But so I came as a neutral party. I just hope that I acted in that manner on your behalf. And thank you for having me.
Thank you, Joe.
Thank you, Joe.
Okay, good night.
Good night.
Good night.
Amy, did you still want to speak?
Yeah, I do. I want to clear up what might be a misunderstanding about the township-wide road SAD. After careful reading of Act 188, I think we did it wrong. I think the previous board did our road SAD incorrectly. We had two things in mind. One was the improvement of all the 20, I think there were 29 connector road segments. We listed them specifically, number of miles or portion of miles, what the surface was, what we were going to do, and what the cost was. And I think that's a requirement of Act 188, is that you have to list the projects you're going to do and what the cost is. What we didn't list was the things we wanted to do for the transportation alternative planning part. And in fact, we did not, in the initial passage of the road SAD, we did not even include the language to allocate the 10% of the $5 million to TAP. Even though every presentation to the board, every presentation to the public talked about this 10%, it was never allocated in the ordinance. We had two lawyers working on this thing. Luke Hitter's a lawyer, Spalding Clark's a lawyer, but they're not competent in the Act 188, I believe, and that's how we got into this mess. I relied on their advice, but I think the board got it wrong. And the reason why we got it wrong is because Act 188 says specifically that the improvement must benefit the parcels that are taxed. We've taxed all, we allocated or took money from all 6,200 parcels of the township at $85 a parcel. 10 years, it's $850. It's hard to argue that someone's parcel was not increased in value over 10 years by $850. That happens just by inflation. So it has nothing to do with the actual projects that we did. But what the board thought was that if Scio Township improved all their roads, paved these roads, made them better, that the whole township would have a better view as far as a place to live, a place to work, a place to build business. So the township itself would increase in value. Whether that is right or wrong, probably is a matter for competent legal advice, possibly even a judge. So that's what our theory was, but I'm not sure that we should have used an SAD to do what we did. Probably should have been a millage, because a millage is for public benefit. An SAD is for specific, if you want to call it, it's not private benefit, but for specific parcel benefit, not overall public benefit. And I think we were aiming for overall public benefit by doing this. And I think we should not have done it as an SAD. We should have done it as a millage. So I would ask that if you're going to renew this thing, I would ask that perhaps it needs to be renewed as a millage, but again, competent legal advice. I think we might have two lawyers on this call right now. I saw Jim. I don't know if Mike's there. So, okay. So
No, Mike's not.
my concern is the allocation of that $500,000 to the TAP would have been legal if we had listed Zebra Road Pathway and the bridge over 94 as one of the projects when we initially implemented this thing. I think that then we probably would have been okay because Act 188 says you can do that as long as you list the projects. You can because Act 188 allows you to allocate money for paths, sidewalks, garbage disposal. There's 20 things you can use Act 88 for and 188 for. So, but because we didn't list that, I think what we did was wrong, allocating that money to TAP. So I think what we have to do is rescind one of the last motions the previous board did by adding the 11th whereas to the, or the therefore to the ordinance. Have a public hearing, add the Zebra Road Pathway to the previous SAD, and then add the 10% for TAP to the ordinance. I mean, that's what should have been done because the Act 188 says in section 4, whatever, 4.472, whatever it is, says it can be changed, but it has to be changed at a public hearing. So, and we didn't do it. We changed the ordinance, but not at a public hearing. So, and we didn't add the projects that the money was going to be allocated for. My vision was that it would be allocated for bus stops and traffic lights and crossings and pedestrian things. It turns out it's been allocated to a bridge across 94, which is good, and the Zebra Road Pathway, which is good. My mind, that's money that should come from the pathways millage, but I'm not on the board, so I can't allocate that. I can't decide that. But that was the envision of what TAP was for. I think that's all. Yes.
Oh, yes, to back up what you said, the Michigan Municipal League is the educating body of like cities and villages and whatnot, where we have the Michigan Township Association. So the MML has chapter 21 and it specifically talks about special assessments and user fees. So it says, while a special assessment bears some of the characteristics of a tax, it differs in that a special assessment may be levied only on land and may be imposed only to pay the cost of an improvement or service by which the assessed land is especially, as opposed to generally, benefited. In contrast, a broadly imposed tax yields a general benefit to the community with no particular benefit to any person or parcel. So that's the difference between a SAD or special assessment and a tax. Millage, sorry, millage. I guess that's a tax.
And I think a millage also, I'm not sure, but I think a millage would have to be voted on.
Yes, and then what Joe had said, a special assessment millage, as long as it was voted on, could be considered a special assessment. Like, I think we did that with the fire, but that's under Public Act 33. That's way before my time, so. One
resident did have a question, I can't remember who it was, about whether or not the SAD assessment has to be paid off when you sell your house. And it's my understanding, which I've told, when I was on the board, I told this to everybody, the special assessment is a lien. And it's my understanding that when you sell your house, liens have to be paid before you can close. So that's why I've been telling people that the special assessment, however many years, it's a total of $850. If there's 5 years left, it's 406, whatever, how many it is, has to be paid off when you sell your house. But I'm not a lawyer, not a real estate agent, but that's my understanding.
That was actually John Boyd did come up with the same answer on the chat.
Oh, okay.
And that's what I'd heard as well.
Right. Okay.
Caveat, not a lawyer.
So for what it's worth. Okay, thank you.
All right, so I think we're finished with the presentation. We're not doing any unfinished business this evening. Patrick was kind enough to provide us with a TAP report and a, what did you call it? It was a-
Call it the Joint TAP RAC Committee on Township SAD.
which I included late, it didn't get into the original packet. But
And obviously, there's a lot of food for thought that was put on the table today that we need to consider.
I would like to carry those forward to the next meeting, and, yes, there's a lot to consider. Kathy, did you have any other?
I can
wishes
just
for trustees or-
briefly update, at our last board meeting, we had the issue of the point, considering appointment of a trustee, and that was tabled. I think everybody in the room knows that. And then we received correspondence from the 3 remaining candidates. Jillian had already withdrawn, that they were all withdrawing. So that's what happened in the board.
The DDA is meeting on Monday, the 12th, so I'll bring up DDA. Or report to the next meeting. Does anyone else have anything else they need to add to this evening's meeting?
I think we need to resolve this Park Ridge
All right, please.
issue. Why don't you go up so we can talk? Because there seems to be a big misunderstanding. And Amy was on the Zoom, she's not on right now, but Amy Friedman, Lisa Silver, they came to us, and we had a meeting with Will and the two ladies, and Roy Townsend was here. This is going back a couple of months ago.
Can I interrupt right there? I thought the first step in the process was a petition.
No, the first step is they brought to us, they had a need.
No, that's not this,
And-
that's not the step according to the
No.
Act 188. That's your made up process.
No, it is not our made-up process.
Yes, it is.
No, it's,
Wait, let's
We
back
just
up.
confirmed it with
There
Joe
was a
Turner.
petition process that began a few years ago, which started and they went through, Park Ridge went through and up to a certain point, it was, the road commission was brought in. Now, I wasn't part of this, but I think Kathy, you
I
remember.
was, and it
that-
was abandoned.
It was
It was
so.
abandoned.
I think the implication is that there was malice, and I think what Bob is correctly saying was there was no malice. And yes, we did it incorrectly. And obviously, we've learned a lot tonight. And I would caution all of us to put everything on hold until we figure out how to do this. But I think that there was no malice intended. We were approached by people in that area, and we were trying to work with them to do the right thing. And Bob has been doing it in totally good faith. So that's.
The phrase I used is you guys are running willy-nilly. That's not a malicious
That may be
description.
true based on what we heard tonight, but again, it was with good intentions.
it was with common sense.
But where I object is that my road was gonna somehow be extended into this abandoned
Not true,
petition.
not true.
Bob, I told you where that came from.
Where did it come from?
I did say,
It
I
came
posed
from
a
a
question.
meeting.
I
Wait a
said,
minute.
should we have a discussion with adjacent roads?
You specifically mentioned Roseland.
And I think I may have used the word Walnut as well, having driven that neighborhood.
So
That was not.
I'm
It was
alarmed.
not- It was not an alarming
I'm alarmed
intent.
because I travel those roads all the time. I don't have to go down Park Ridge, but sometimes I do. They just graded all the roads in the neighborhood. And those roads are fantastic now, including
Which again
Walnut.
is thanks to the township-wide SAD. That those roads are
I
getting
really think
maintained.
you ought to listen to what transpired before you jump to conclusions.
I'm not sure that the township,
Give her a chance to finish.
I thought the county did though that grading.
Well, my understanding is that we have to pay, the township pays 50% of the costs
No.
to Washington Road Commission.
No.
We pay a portion.
A portion for
portion.
for grading?
Yeah.
All grading?
I believe so.
Yeah. And, if you look at some of the other roads that have been tackled, there's a reoccurring maintenance schedule to actually upgrade and work on the roads, and that does come from that SAD. So yeah, it's all funded by Scio Township. 50% is my understanding with Washington Road Commission.
Okay, so
Separate issue, to be honest. I mean,
it's not a separate issue if two residents are coming and asking for an estimate to make improvements where improvements were just made to those roads.
that's not what we would. Park Ridge, it was, when this whole thing came up, it's a disaster. There are huge problems with water runoff going over. I'm sorry, but I was sitting here listening to the commentary.
I was too, because I come to all these meetings and I live in that neighborhood. And the complaints came during the spring when we get potholes.
Yes.
They,
And the question was, please, can we work with you to do something about it? So again, in good faith, that's what we've been engaged in. There's no malice, nothing's been hidden.
well, I'll take that as when I heard my street being included.
It wasn't included, it was literally mentioned. Should we talk to, Linda just said, should we talk to other people in that neighborhood? It wasn't any intention to do it or not to do it. It was, should we ask? It's a reasonable question to ask. It doesn't mean that we were planning to do it. There was no malice.
Understand, and I appreciate that feedback. It is a reaction to how SADs have been administered in the past in this township.
I think we as a road commission are learning that. And again, none of us are here volunteering to do harm to people.
So apologize for delivery. I will certainly do that. The reaction I think is warranted, the same as the folks in Liberty Hills being assessed twice for two assessments, two special assessments, and they still have drainage problems.
So I'm grateful for Jillian for bringing in Joe Turner. I think we've learned a lot, and there's obviously a lot we have to think about.
Not things we will resolve this evening, unfortunately. I would encourage anyone who is got time, the next meeting is October 5th, which is the first Wednesday in the month of October. To really plan to be here. I think it will be a very important meeting for the direction that the committee is going to be taking. No one else has any other, board members have any other comments?
Kathy, were you assigned, what were you assigned last? You were assigned something last. Yeah, you had.
Oh yeah, to talk to the attorney about.
Oh, I did that. I
and you-
mailed the questions to all of you.
Yeah,
I did that. I
It
thought
was-
there was something else.
yeah, it was
Oh,
great.
no, that's what it was.
I mailed the questions and answers to the entire committee.
And what, okay, so. All right, I think maybe we should say the questions and answers out loud for the public.
That's fine. Next time we can.
Okay.
I can add those to the packet
Yeah,
next time if you'd like. I wasn't
mean,
sure if it was
so
appropriate, so I actually wanted to ask Kathy.
I asked him if I could share his responses with the committee. I did not ask him, can we just publish your responses? So that's a slightly different question. I think it's probably okay, but maybe we should check.
Once you shared it with the committee, it's public.
Yeah.
Okay.
I can add those to the October
Yeah,
agenda.
go ahead.
All right, in that case, I would call for an adjournment for the meeting. Would someone make a motion?
We have a raised hand. Rob Patterson's got his hand up.
There was public comment as one of the last
I'm
things on
sorry,
the agenda.
Yes.
Yeah.
We're doing more public comments. All
Okay.
right, if Rob Pattinson would like to speak, I guess.
Yep, I just unmuted.
Thank you.
Rob?
Thank you for that. I think we learned tonight that this process is a heck of a lot more complicated and full of landmines than we thought, and we need to proceed carefully. So thank you all. Thank you, Jillian, for bringing Joe Turner And thank you to this committee. You have one of the hardest jobs in Ohio Township. You're starting from scratch and you've got a lot of wounds to heal and you've got to establish a fair and transparent process. So well done.
I don't see any more hands. Yeah. Good.
All right, so Ian's made a motion to adjourn. May I have a second? Kathy Knol seconded the motion. Meeting is adjourned at 9:01 p.m. Next meeting, October 5th, please.
Before you all leave, I want to thank you for how you ran this meeting, allowed the public to ask questions. That is very healing. And appreciate, Ian, that you calmed me down and it wasn't intended to be malice. If our board of trustees could do some of the things that you guys are doing, it would go a long way to heal distrust. So I appreciate you.
Yeah.
Thank you, Kevin.